Well, there you have it. I mean, I can apologize. I can admit when I'm wrong.
You love helping your customers, but it's hard to keep up with their increasing service expectations.
Today's courtroom proceeding stems from a case that we previously covered on Audit the Audit involving the March 6, 2024 arrest of an individual named Damien by Deputy Tyree Holdridge of the Douglas County Sheriff's Office in Nevada. Now, because this episode builds directly on the facts and legal issues that were discussed in that earlier coverage, if you've not seen it, or if it has been some time since you last watched it, I strongly encourage you to do so before continuing with this episode, as watching the prior episode will give you the necessary factual context and legal framework to better understand the charges addressed in today's courtroom proceeding. I've included a link in the description down below. After his arrest, Damien was prosecuted in the 9th Judicial District Court in Douglas County on a single charge of obstructing a public officer in violation of Section 197.190 of the Nevada Revised Statutes. As we discussed in the prior Audit the Audit episode covering Damien's arrest, that statute makes it a misdemeanor offense to willfully hinder, delay, or obstruct a public officer in the discharge of their official powers or duties where no other provision of law applies. On June 21st, 2024, the case proceeded to a bench trial, meaning that the charge of obstructing was tried and decided by a judge rather than a jury.
This is State against Damien, number 24, CR 181.
Phil Murphy on behalf of the state.
Good afternoon, Your Honors. Judy DeSombro with Joy Gilbert Law on behalf of the defendant, Damien, who does appear in person.
Parties ready to proceed?
Yes, Your Honor.
Go ahead.
Yes, Your Honor.
Either party wish to invoke the rule of exclusion?
No, Your Honor.
Your Honor, the defense would invoke the rule of exclusion.
Okay, the rule of exclusion's been invoked. What that means is that if you're here to testify in this case, then you can be inside the courtroom when you're testifying and not otherwise. And you can't discuss your testimony among yourselves or with anyone else except the lawyers in the case. So who's your first witness, Mr. Murphy?
Deputy Tyree Holdridge.
Deputy Woolridge, I'm sorry, did either one of you wish to make an opening statement?
I'll make a very brief opening statement if you want, Your Honor.
Do you want me to excuse the witness while he does that? Does it matter?
It does not matter to the defense. Your
Okay.
Honor.
I'm just going to briefly reiterate the criminal complaint. Mr. is charged with obstructing a public officer on or about March 6, 2024. Deputy Tyree was on patrol in the industrial park of Douglas County. He came upon a car that was on a curb with items being taken out of the car. He went to investigate to see if there was any criminal activity afoot. He asked Mr. to provide him an ID. Refused. He asked Mr. to sit down. Refused. And Mr. did obstruct deputy's investigation as to whether any criminal activity was afoot. So that's very
Okay. All right. You want to raise your right hand? Do you swear under penalty of perjury the testimony you're about to give is true?
Yes.
Okay, have a seat up here. And tell me your name and spell your last name.
Tyree Holdridge. It's Holdridge.
Thank you.
Deputy Holdridge, how are you currently employed?
I'm employed by the Douglas County Sheriff's Office and assigned to the Patrol Division.
And were you on patrol on March 6, 2024?
Yes, I was.
And where were you on patrol?
I was on patrol in Douglas County in the middle of town.
On March 6th of 2024, did an incident happen that brings you to court today?
Yes, it did.
Okay. Start at the beginning and tell us where you were, and then we'll take it from there.
On March 6th, at about approximately 23 hours, I was patrolling the industrial area of Southgate Drive and Pep Circle.
Okay. Let me interrupt you very quickly. That area that you're describing, is that located in Douglas County?
Yes, it is.
Okay, please proceed.
As I was passing the intersection of Pep Circle and Southgate Drive, I observed what appeared to be two males opening the back door of a blue Honda at that time.
Well, let me back up. You said that it was what time at night?
21:23.
What does that mean in civilian time?
Approximately 9:30.
And did the two males taking things out of the vehicle arouse your suspicion in any way?
Yes, it did.
Okay. And as part of your duties as a law enforcement officer with Douglas County, do you patrol the industrial park and look for any criminal activity that might be afoot?
Yes, I do.
Okay, please proceed.
I observed two males that were dressed in dark clothing pulling items out of the back of the vehicle. Because of the area and that it's usually operational during business hours, I made contact with the two males to see if that vehicle belonged to those two subjects or if they were actually attempting to burglarize the vehicle.
Where did you position your vehicle in relation to where the suspect vehicle was?
I positioned my vehicle, I parked in the middle of the street, turned my spotlights on, and I was south of the vehicle.
Did you exit the vehicle?
Yes, I did.
Okay. Did you activate your body cam?
Yes, I did.
Okay. And when you parked your vehicle, what were you driving?
I was driving a Chevy truck that's fully marked.
When you say fully marked, is that vehicle readily identifiable as a Douglas County Sheriff's Office patrol vehicle?
Yes, it is.
Okay. And when you got out of the vehicle, what were you wearing?
I was wearing a full Douglas County uniform that identified myself as a deputy sheriff.
Okay. Is that similar to what you're wearing now?
Yes, it is.
Okay. So you have the badge?
Yes, I did.
You have the vest?
Yes, I did.
You have the badges on your shoulder?
Yes. And asked what they were doing. They told me not to worry about it. The person that was there was complied with everything. The other person did not.
When you got out of your vehicle, did you have a partner with you?
No, I did not.
Did you have any backup coming?
No, not at that time. I did not.
Okay. So is there an extra? Okay. So please proceed.
Because I was on the curb, so I could figure out what was going on. Identification. He told me I didn't need it. He beat it again, so I grabbed him because I had any weapon. Yes, I do.
What is this?
It's a USB with a video recording.
Recognize the white scan. What is this a USB of?
The incident on March 6th.
I'd like to show him the video before I publish it.
Is there an issue on the authentication?
Your Honor, I do not believe there's any issue with authentication.
Okay.
I move for the admission. Well, Mr. Clerk.
Go ahead.
Thank you. Now I move for the admission of State's Exhibit 1.
Is there an objection?
No objection, Your Honor.
Are the right buttons still pressed here? Looks like they are.
Good. What are you guys doing?
So Deputy Deputy Holdridge, do you recognize this video?
Yes, I did.
Is this the video that you previously watched in my office?
Yes, I did.
Okay. And is this the same video that you put your initials on?
Yes, it is.
Okay. Having viewed this video, is it a true and accurate representation of what happened on the evening of March 6, 2024?
Yes, it is.
Okay. And if you can identify where this video came from?
Came from my body camera.
Okay. And just to make sure that we don't have any true jurisdiction, did this happen, this whole incident happen within Douglas County?
Yes, it did.
Okay.
Good. What are you guys doing? Is this your vehicle?
Father?
Do you guys have your IDs on you?
No.
Not at all?
Tell us what we did wrong?
Yeah, you're in a business area. And it's all closed, and I don't know this is your dad's vehicle. Actually, why don't you have a seat? Have a seat right here.
Oh, the door open? Actually.
Have a seat.
Sorry, I don't listen to you.
Have a seat.
Snap your W-2 and file your taxes 100% free. Plus, get your biggest refund. Roughly 37% of filers qualify. Simple Form 1040 returns only. No schedules except for earned income tax credit.
Okay, so let's have a very quick conversation about what's happening here. So there's a person on the right hand of the screen. Is that the person that's in compliance?
Yes.
Okay. Is there a person on the left hand of the screen?
Yes.
Okay. And were you able to later identify that person?
Yes, I did.
Okay. Do you see that person sitting in court today?
Yes, I do.
Would you please identify where they're sitting in an article of clothing that they're sitting?
I'm sitting next to the defense attorney wearing a black shirt.
Now, let's talk about why you asked these two people to have a seat. What was the purpose of asking them to have a seat?
I don't know at the time of the night where they're at. I don't know if they have weapons on them. So for my safety, because I didn't have any other backup with me, I requested they sit on the ground until identified so I can conduct if that was their vehicle or not.
Okay. And the person on the left who you identified as defendant, did that person comply with that command?
No, he did not.
318, can I get a second? You have a seat right here.
Don't touch me. Don't touch it. Get the off me.
So what was your rationale for going to hands-on with Mr.
The fact that he was fidgeting in his left pocket, he was wearing dark clothing, wasn't obeying commands. I don't know if he has a weapon. There's two of them. There's one of me. So I wanted to be in control at least of one of them.
Is our safety consideration when you're encountering two people at night?
Yes.
Just to back up to make sure I understand your testimony, is you encountered this situation. What was the purpose of asking those people for the identification?
to confirm if they were the registered vehicles of the owner or if they have the same last name as the registered owner on the vehicle.
Okay, so you attempted to investigate.
Yes.
But Mr. interfered or obstructed your ability to do that investigation.
Yes.
And then you gave him a command to sit on the ground. Is that correct?
Yes.
Did he refuse to do so?
Yes.
And at that point, he was fidgeting in his pocket, so he decided to go hands-on?
Yes.
And was that an officer safety call?
Yes.
318, can I get a second? You have a seat right here.
Don't touch me. Don't touch it. Get the off me.
10-10.
There's a cuff on me. Get him off.
I said get on the ground. All right?
There's a cuff on me. Get him off. You're choking me. Get him off. Don't even record the.
I said get on the ground. I don't know what you're doing.
What did I do
Have a seat
wrong?
on the ground right now.
What did I do wrong? What did I do wrong? Is your camera on?
Yeah, it's on.
Get the off of me. Ow! Get off!
Roll on your stomach.
No! I'm not listening to you. Get the.
Let's pause very quickly there. What was the purpose of you telling Mr. to roll on his stomach?
So I could put him in handcuffs.
And why did you make the decision to put him in handcuffs?
Because I had one other person that was still behind the vehicle.
Okay. So was he under arrest for anything, or was he being detained?
He was being detained.
Off of me. Start recording. End the call. End the call, start recording, please. End the call, start recording.
Get another game.
Yeah, ID number. Give me your ID number. Where's the sheriff?
Stay right there.
Get the off of me. Ah, mother.
Get on the ground.
Why?
Because I said.
911. What did we do wrong?
I told you what.
What's the charge? Get the.
Did you take Constitution in that? I'm
under arrest. I'm under arrest.
You're being detained.
Over what? Over what?
We're here. We're allowed to be here.
I don't know that.
We're working on a car.
I don't. Hey! I don't know this is your car. It looked like somebody was breaking into your car. I did.
That's your action? No probable cause? No investigation? Just put him down?
He's gonna straight jump up on me, huh? Real gang member, huh? Real big man, huh?
Have the shop behind Douglas Radiator.
The off of me.
I don't know that.
Who's your job?
Okay, well, I'll wait till my partners get here until we get
Get the off of me.
You have no reason, you have no probable cause.
I do.
Over what? Say it. Say your legal probable cause.
Were you investigating suspicious circumstances?
Yes, I was.
Is it part of your job to investigate suspicious circumstances?
Mr. Murphy, this is the third time you've been through this. It's not necessary. It's a trial to the
Okay,
court.
then I will pass the witness.
After the prosecutor finishes questioning Deputy Holdridge on direct examination, Damien's defense attorney has the opportunity to cross-examine him. Cross-examination allows the opposing party to question the witness about matters raised during direct examination as well as issues affecting credibility. Unlike direct examination, leading questions are permitted, allowing defense counsel to more directly challenge the witness's testimony and version of events.
You stated to the state that at the time of this incident at 9:30 in the evening, partially why you approached the situation was because of the fear of what happens at night. What is the importance of this event occurring at night as far as how you then approach your investigation? Do you have any different policies on how you approach an investigation, whether it is daylight or at nighttime?
No, I do not.
So there was no additional danger because this was occurring at night?
There was.
So how do you approach that additional danger?
You spotlight them and you control the subjects.
At what point do you consider that an investigation becomes more dangerous because of lack of daylight? Is it as soon as it becomes dark? Is it at 1 a.m.? Is it at midnight?
There's a lot of circumstances.
Can you elaborate on that?
The time of day, the area they were in.
And you said this occurred approximately at 9:30.
Yes.
There's still a significant amount of people out and about at 9:30, is that correct?
Not in this area.
I wasn't asking about the area. People are typically still awake and conducting their day-to-day lives at 9:30, correct?
Yes.
How familiar are you with this particular industrial area?
I'm very, very, very familiar.
Are you familiar with Douglas Radiator?
Yes, I am.
Are you familiar that they work there outside of the scope of 8 to 5?
They usually don't.
And how are you familiar with their business areas?
Because I'm friends with the owner.
When you approach the subjects, do you recall one of the subjects presenting car keys?
No, I do not.
Can we replay the body camera owner?
You guys talk between yourselves. I don't direct that.
And we previously reviewed your body cam footage already in court.
Yes.
If we reviewed the footage, would you recall if either of the subjects presented car keys?
If I wash their hands, I guess so.
Here we go.
Good. What are you guys doing? Is this your vehicle?
Father?
Do you guys have your IDs on you?
No.
This is the same body cam we reviewed earlier, correct?
Yes.
Do you now see one of the subjects holding up a pair of keys to
Yes.
approach the vehicle?
During cross-examination, Deputy Holdridge falsely claims that neither suspect showed him the keys to the vehicle during his investigation. In response, defense counsel uses the deputy's own body camera footage to, quote-unquote, refresh his recollection. Refreshing a witness's present recollection is a common courtroom practice that is used when a witness claims not to remember a fact. The questioning attorney shows the witness a writing or another record, such as the body camera footage here, in order to help them remember the answer to the question. The purpose is not to introduce the record itself as evidence at that moment, but to prompt the witness to testify from an accurate present memory after reviewing a contemporaneous record. After the witness reviews the record, they must testify from their so-called refreshed, independent recollection of the events in question.
Did you see those keys at that time?
No, I did not.
Did you recall either of the subjects stating that it was their vehicle?
They stated at it, but if you look at the vehicle, it's not parked in a regular parking spot. It's parked halfway on the street. It could have been stolen. They could have had the keys.
Did you take any additional action to ask them about the keys or about their ownership of the car?
I didn't even see the keys.
Did you ask them any additional questions about their car? Or their
Not after
ownership of the car?
Mr. became uncooperative.
Is there any way you could have identified their legitimacy to the car outside of an identification?
If they would provide their identification.
Is there any additional way you could have?
I could have.
How would that be?
They could have complied.
Is there no other investigation you could have taken to establish legitimacy of the ownership of the
Once they
car?
become uncooperative, it became an officer safety issue. I'm not going to walk back to my car and turn my back to two people that are wearing dark clothing in a dark, unlit industrial area.
What is your reasonable suspicion that a crime is occurring at this?
That they're breaking into a vehicle.
What is the reasonable suspicion for you to have made a determination that they are breaking into a vehicle?
That it's a dark, unlit business area. The car is parked not in a parking spot. It's parked halfway on the sidewalk. They're not answering any questions. They're wearing dark clothing, and they're in a business area where there's no people.
Do you recall what date this occurred?
Yes.
What is that?
March 6th.
And that is typically a cold time of year, right?
Yes.
Typically a time when people wear sweatshirts.
Yes.
Was there anything out of the ordinary that they were wearing sweatshirts?
I mean, I was wearing a short sleeve that night. It wasn't that cold.
But it's early March, and it's typically cold at night.
Yes.
So you determine, based upon dark business area, people approaching a car, that's reasonable suspicion to then identify an investigation of a burglarized car.
Yes.
So do you approach people in any dark business parking lot regarding burglarizing a car?
Yes, I do.
Any person that is in a dark parking lot
Yes, I do.
at night.
That's my job. I don't know.
When you approach a subject who is not burglarizing a car and is merely in a after-hours business parking lot, are they typically happy about compliance?
Yeah, 100% of the time.
Well, not 100%, because here we are.
Every time I've contacted somebody, they are more than willing to comply to show that it is their vehicle that they're not breaking into. I mean, look at that subject compared to the other subject. The other subject complied and he sat down. He wasn't arrested. This subject didn't comply with verbal commands and he was arrested.
Did you conduct any further investigation into the ownership of the car following this body cam?
I did after my partners arrived on scene.
And what did you determine?
That the vehicle belonged to the father.
It wasn't stolen.
No, it was not.
It was not burglarized.
No, it was not.
Was my client trespassing?
I don't know.
Were you able to determine was he trespassing?
He was not. Later it was. He was not trespassing. But at the time I did not know that.
Is it safe to say that outside of this charge that we're here on today, or March 6th of 2024, that my client was not engaged in any unlawful conduct?
Yes. If he would have complied, it would have been a 2-minute contact.
That's not what I asked. Thank you. Are there any Douglas County policies on de-escalation?
Yes.
What are those policies?
If a person doesn't verbally listen to verbal commands, you take the next step up above.
What does that mean?
He didn't verbally comply, so I went hands-on.
And that's the policy of Douglas County?
Yes.
That you go hands-on following any refusal?
Yes. You always stay one step up above what the subject's actions are.
And that's considered Douglas County's de-escalation policy?
Yes.
Are you familiar with the word de-escalation?
Yes.
So you are testifying that escalating a situation is Douglas County's de-escalation policy?
I'm not going to sit there and de-escalate and have him pull a gun out and shoot me.
Nothing further from the defense, Your Honor.
Okay. Any redirect?
Just very briefly, a question was posed to you about when you make contact with people potentially in parking lots after hours in the dark. Are those people generally appreciative that you're making sure that their cars aren't getting busted into?
Yes, they are.
Thank you for your testimony. I pass the witness.
No follow-up, Your Honor.
Okay. Can the witness be excused?
Yes, Your Honor, and not subject to recall. I'm not doing something.
Okay, you're excused.
Scribe makes step-by-step guides for any process with AI. You know what's terrifying at work? When you start a new job and there's no training, none of the processes are documented, and you're completely on your own. Let me show you one of the best kept work secrets. It's called Scribe. Go to scribehow.com, click Capture, do the task once, and Scribe will create a step-by-step guide you can share automatically.
Okay, you're excused. Thank you.
Deputy Holdridge is then excused from the stand, and the prosecution rests its case, having presented only a single witness. With the state's evidence complete, the defense has the opportunity to call witnesses in Damien's defense. Though Damien is under no obligation to present any evidence at all, the defense elects to call Jonathan Hollingsworth, who was with Damien on the night of his arrest, to testify.
Do you have any witnesses or
We do, Your Honor.
evidence?
We have one witness.
Okay.
It would be Jonathan Hollingsworth, Your Honor.
Okay, Mr. Hollingsworth. You want to raise your right hand for me, please? Do you swear under penalty of perjury the testimony you're about to give is true?
True, Your Honor.
Good morning, Mr. Hollingsworth. Are you familiar with Damien?
Yes.
How are you familiar with him?
I've known him since he was like 3.
So for a lifetime.
Yeah, he's a family friend.
So you would consider him a friend then?
Yes.
Are you familiar with Douglas, I apologize, Douglas Radiator?
Yes.
Do you spend time there?
Yes, I help work on cars there.
And what's Damien's relationship to Douglas Radiator?
He works there off and on too.
When you're there, are you often working with this?
Occasionally, yeah.
Were you at Douglas Radiator on March 6th of 2024?
Yes.
What were you doing at Douglas Radiator on March 6th?
I was working on a car.
Were you there all day?
I was there till about 11 o'clock at night.
And were you with Mr. on that day?
Yes.
Were you working on a car together?
Yes.
What was the plan after you guys completed working on the car?
The plan was to go to the car and grab the bedding because there was a loft in the shop. That's where we would stay until we could work in the morning.
So I'm going to back you up a little bit. So you were working on a car.
Yes.
That was at Radiator.
It was at Douglas Radiator.
And then you say you went to a car to get belongings.
Yes.
Was that a separate car than the one you were working on?
Yes.
Was it outside of the shop?
Yes. It was across the street from the building that we were at. It was at the other building. There was 2 buildings. It was on Douglas Radiator property.
And who had the keys to that car?
I did.
And did Mr. go to the car with you?
Yes, he did.
When you got to the car, were you able to find your belongings?
Yes.
While you were looking for your belongings, did anything out of the ordinary occur?
Yes. We were approached by an officer. I didn't understand why. I proceeded to continue going through the car. That's when Damien was tackled.
So you had the keys to the car when you approached the car, correct?
Yes.
Did at any point in time did you attempt to present the keys to the law enforcement officer?
I showed him the keys.
Were you surprised by law enforcement's presence?
Yes.
Was there any reason to believe that you needed law enforcement assistance?
No.
Did you believe that you were participating in any sort of criminal act?
No.
And just to reiterate, had that night gone as planned, you were going to stay the evening at Douglas Radiator?
Correct.
With Mr.
Yes.
Nothing further, Your Honor.
Mr. Murphy?
I don't have any questions on this witness.
You can step down. Can he be excused?
Yes, Your Honor.
You're excused, Mr. Hollingsworth. Thank you for coming in. Do you have anything else?
Nothing further, Your Honor.
Okay.
Once Mr. Hollingsworth finishes testifying, both the prosecutor and defense counsel are given the opportunity to present closing arguments. Closing arguments are not evidence. Rather, they are each side's final chance to summarize the testimony and exhibits already admitted, explain how that evidence supports their respective theories of the case, and argue how the law should be applied to the facts. Attorneys may draw reasonable inferences from the evidence, but they may not introduce new facts or refer to evidence that was not admitted. In a jury trial, closing arguments are often more narrative and fact-driven, aimed at persuading jurors by organizing the evidence into a coherent story while explaining in plain terms the law they are required to follow. On the other hand, in a bench trial, closing arguments are typically more focused on the legal standards and how the evidence does or does not satisfy each element of the charged offense, because the judge serves as both the fact finder and the arbiter of the law.
I'll hear closing remarks.
Thank you, Your Honor. So, on the evening of March 6, 2024, Deputy Holbrook was on patrol, routinely checking the industrial park, make sure no criminal activity was afoot. He, as the video shows very clearly, it's completely undebatable, is he was patrolling, he saw a car parked in a weird way. It wasn't parked in a parking stall, it was parked on the side of the street with part of it hanging into the gravel where the sidewalk is. So he did what he is paid to do. He started an investigation. He developed a reasonable suspicion that there may be criminal activity afoot. So he parked his vehicle in a way that he could try and see what was going on. He was in his law enforcement vehicle. He was dressed in...
I forgot to ask him, Mr. Murphy, one of those black pickups with the stenciled sides, or is it a black and white one where you can tell it's a cop car?
When I went through the direct examination, I asked to know if there was the markings on the side and if it had the lights on the top, and he acknowledged that they were.
Okay.
And so he was unmistakably a law enforcement officer. He tried to do an investigation, and he asked them for their identifications. There is always a compromise for officer safety and taking into consideration the feelings of the public when you want to see if a crime is afoot or not. Of course, you don't want to hassle people that are doing nothing wrong, but you also have to make sure that you're going to go home that night and that somebody's not going to pull out a weapon and kill you. So there's a compromise that has to be made. So Deputy Holbrook started his investigation. He asked them for identification. The last witness, Mr. Hollingsworth, started to comply when they didn't produce their identifications, and Deputy Holridge told them to sit down. Mr. Hollingsworth started to do that, but Mr. said, no, I'm not doing that. Well, based on the time of night, the situation that they were in, and Mr. blatant disregard for the deputy's commands, the deputy again said, tried to get him to comply before he went hands-on. Mr. wasn't having any of that. Mr. quite frankly had an attitude. And he says, no, I'm not going to do what you tell me to do. So deputy went hands-on. It was a sticky situation, and he did what he had to do to protect himself. As the deputy testified, it was dark, and he could not tell if they had any...
Well, we're not debating whether reasonable force or not. What we're debating really is reasonable suspicion to interfere with their liberty by asking for identification, correct?
Well, there are two cases that associate that. One is the Heibel case from the United States Supreme Court that stated that if an officer or law enforcement has reasonable suspicion that a crime exists, then that person is obligated to identify themselves. And that's been codified in the Nevada Revised Statute, which I call the Heibel statute, which states that if an officer has reasonable suspicion to determine that there is criminal activity, then that person is required to identify themselves.
Okay, I understand.
When the deputy was investigating as to whether this car was being burglarized, Mr. completely shut down his investigation.
So let me ask you something, Mr. Murphy. Do you think it supports an obstructing charge if someone declines to identify themselves? Forget about the physical restraint. Forget about the time of day. If a person declines to identify themselves in that circumstance, does that constitute the crime of obstructing?
It does, Your Honor. And because the United States Supreme Court has stated that if an officer has reasonable suspicion and he's investigating a crime, that person is legally obligated to identify themselves.
If you struggle with focus, this sound might change everything.
On March 7th, 2020, 23-year-old Keelan Hawkins was arrested and charged in the Harris County criminal courts with driving while intoxicated. That same day, she was released on a so-called general order bond under Harris County Local Rule 9, which requires that, with the exception of defendants in certain so-called carve-out categories, all misdemeanor arrestees must be given an unsecured personal bond and promptly released, without the need for a judge to sign off first. In other words, for most misdemeanor arrestees in the county, release happens automatically, and the sheriff is instructed to let the person go without collecting an upfront payment or holding a separate in-person bond hearing. Harris County's general order bond system is unique, as it was created as part of the November 21st, 2019 consent decree resulting from the 2016 class action lawsuit of O'Donnell versus Harris County, which alleged that the county's then existing misdemeanor bail practices were unconstitutional. The consent decree imposed bail reforms in Harris County, including the implementation of the general order bond. After Ms. Hawkins was released on a general order bond, her arraignment was scheduled for March 13, 2025 in the courtroom of Judge David Fleischer, who was tasked with determining whether there was probable cause to support the DWI charge and revisiting the issue of bail. Ms. Hawkins' defense attorney of record was Greg Holton, but Mr. Holton's colleague, Aaron White, handled the arraignment.
Good morning, Ms. Hawkins. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On March 6th, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy eyelids, and a strong odor of an alcoholic beverage. And the officer found a large cup holder. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a specimen. A blood search warrant was signed and executed.
Are you telling me that she has alcohol in the car while she's driving?
She had a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds, ma'am. You're not allowed to drive. I'm taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for now.
After finding probable cause for the DWI charge, Judge Fleischer placed so-called conditions on Ms. Hawkins' bond, ordering her not to consume any alcohol and not to drive at all, despite the fact that the prosecution, in a written motion, had only requested that Ms. Hawkins be required to install an ignition interlock device, or IID, which is a breathalyzer installed in a vehicle that prevents it from starting if alcohol is detected in the driver's breath. Under Article 17.441 of the Texas Code of Criminal Procedure, judges must require defendants charged with repeat DWIs or aggravated offenses such as DWI with a child passenger to install an IID as a condition of release. Now, because Ms. Hawkins was a first-time DWI defendant, Article 17.441 did not mandate an IID in her case. However, under Article 17.40 of the Code of Criminal Procedure, judges have broad discretion to impose, quote-unquote, any reasonable condition of bond related to the safety of the community. Now, while judges cannot use bond conditions as a form of punishment before a conviction, as the 14th District Court of Appeals in Houston explained in the 2022 case of Ex parte Bucks, appellate courts review challenges to bond conditions under a so-called abuse of discretion standard. This means that a trial court's decision will not be overturned so long as it falls within the quote-unquote zone of reasonable disagreement. Well, here, given the allegations that Ms. Hawkins was driving while intoxicated and had an open container of alcohol in her vehicle, it is highly highly likely that a reviewing court would conclude that Judge Fleischer's restrictions prohibiting her from drinking alcohol and from driving a vehicle were reasonably related to community safety, and therefore not an abuse of his discretion.
We're Fora, the modern travel agency, and we are empowering anyone with a passion for travel to earn on the trips that they plan. At Fora, our approach is flexible, which means you decide what your
vehicle were reasonably related to community safety, and therefore not an abuse of his discretion.
Understood.
We can approach at a later date, but
I'm concerned because for her employment, she can't get to and from work, and we can't get an occupational license or something like this. It's a condition of the court. I don't think we have any opposition to putting a lock in the vehicle so that she's not able to drink and then drive. But it just seems like no driving at all seems a bit harsh for a first offense. We don't even know what the blood is at this point.
Get it? But she has alcohol allegedly in the car while she's driving. One would presume that that's a humongous no-no, you know? And I want her to appreciate the privilege it is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and understand that it's a privilege. You could talk here now in front of him. You know, you guys at a later date can come back. I'm always all ears. Like, it's not absolute.
For Greg's purposes, he's going to be.
You need to be careful what you do. There is a fine line between zealously advocating for your client and doing something that either breaks the law, is unethical, that could get you in potential trouble.
On September 14th, 2024, Cesar Moises Capriel Perez was arrested for a DWI offense, and he was charged in the Harris County Criminal Court in Houston, Texas the following day. On November 26th, 2024, Mr. Moises Perez posted $1,000 in bail and was released. However, on December 4th, 2024, a so-called bond condition violation report was filed, indicating that Mr. Moises Perez was in violation of the court-ordered conditions of his bail by failing to install an ignition interlock device in his vehicle and failing to report to Harris County Pretrial Services, the government department that's responsible for monitoring defendants released on bond. A bond forfeiture hearing was scheduled for December 10th, 2024 in the courtroom of Judge David Fleischer, where Mr. Moises Perez was represented by appointed public defender Noah Feldman.
Good morning, Judge.
Hey.
I just want the one thing I'll say. I have my client here on video. He can identify himself if necessary. I'm gonna just put my camera on. So
this is a first for me.
It's a first for the ICE supervisor I just spoke to as well.
Wow.
This is.
I mean, wow.
I don't.
Mr. Feldman, that's some good work, man.
I'm an
Great job.
immigration attorney, Judge. So I mean, and I'm a salaried employee.
Yeah.
Really great job.
Order in the court, going on the record.
So, Mr. Feldman, what's the last name again?
This is Cesar Moises Capriel Perez.
Okay. You requested this hearing, so I'm going to let you start.
Okay, Judge. Well, before I start, I have 10 exhibits. I sent it to the chief last night, and I believe she forwarded it to Ms. Saba. I moved to admit those exhibits, tender them to the state for any objection.
And Your Honor, we would need significant time to look over these because we haven't been able to do so since they were.
Yeah, I have 10 exhibits. It's quite a bit. I get.
If I may. The first exhibit is the ICE detainer. It was in Harris County possession. The second exhibit is the magistrate order in which the state requested an $1,000 bond, which my client posted. The third exhibit is basically an ICE form you can get off the internet. It's a stay of removal form that ICE allows people with final orders of removal to apply for stays of removal that allow them to stay in the country for a limited time and limited purpose.
Is this his or is this just a generic?
Generic.
Okay.
Exhibit 4 is going to be just proof that he's in ICE custody. Exhibit 5 is the bond condition violation report. Exhibit 6 is from the DA portal, just showing the release time from the jail to prove that he was released to ICE. Exhibit 7 is the cash bond that defendant's wife posted. Exhibit 8, to be honest, is unnecessary.
Okay.
Could withdraw Exhibit 8. Exhibit 9 is a sample order of supervision you can get off the internet. It's just standardized form. And Exhibit 10 are this court's procedures that are available on its website about failure to appear and non-appearance. Those are the 10 exhibits.
So for purposes of the defendant, so record, I want to make it clear that Mr. Feldman has his computer, and it looks like I can see the defendant there, and it looks like he can look at us as well, but there's no translator, so does he understand what's going on?
That is correct, Judge. I do not believe he understands what is going on.
So now, State, how do you respond to the exhibits?
Judge, I did not get these exhibits until my chief forwarded them to me while I was in docket earlier this morning. I'm going to need time to review these. I'm not an immigration attorney, so I'm unfamiliar with these documents. I would ask for at least a day just to, or I mean, if you don't want to roll it to tomorrow, just like an hour or so I can read through it.
Sure, of course.
I spoke to the ICE supervisor, Judge, the one handling his ICE case. His name is Jeff Hudson. I relayed defense's requests for an order of supervision, and the officer said, he declined the request. He said that there would be no way that they would release defendant given that he is a flight risk and his assault charge makes him a community risk as well. He also advised that the defendant has been deported before. He advised that the only way to get the defendant over to this court is if you issue a bench warrant, and then they would review that warrant and decide whether or not they would transport him over here, which is what I advised defense before.
After it was revealed that Mr. Moises Perez was being held in the custody of Immigration and Customs Enforcement, or ICE, for a potential immigration would be if Judge Fleischer were to issue a so-called bench warrant. In this context, the term bench warrant refers to a warrant issued by a judge for an individual who is in the custody of another agency and needs to appear in a Harris County court as a defendant. Here, because Mr. Moises Perez was in ICE custody, the bench warrant would request that ICE transfer Mr. Moises Perez to Harris County law enforcement custody so that he could appear in court. However, state judges do not have the authority to force a federal agency, such as ICE, to comply with orders to present.
Let me show you how easy it is to start selling products with AI. Step 1, go to link.
In person. So it would be up to ICE's discretion whether or not they agreed to release Mr. Moises Perez to Harris County custody in response to the bench warrant.
He also said that we can try to work out the possibility of the defendant giving a virtual plea, but in terms of them releasing him.
But we need a thumbprint. I need a thumbprint. I need his signature.
Yes, Judge.
There's no translator there for him now.
Yes, Judge. The officer did also tell me respectfully that we don't really have jurisdiction to litigate this immigration issue.
Sure. What you want is you do not want me to revoke his bond.
That is correct, Judge.
You want me essentially to hold this case open. He's going to get deported, right?
That is my understanding.
Essentially, what you want me to do is you want me to hold this case open indefinitely.
Judge, if I may.
Okay.
Look, to me, for this court to revoke its bond based on these circumstances, I'd like to constitutionalize the objection. I think it would be, a violation of equal protection, procedural due process. I think it would be a violation of Section 11 of the Texas Constitution, which say that all prisoners shall be bailable. Section 13, which say that excessive bail shall not be required. Section 19, which says that no citizen of this state, I don't think they mean U.S. citizen, shall be deprived of liberty, which this would be doing by revoking his bond, without due course of the law of the land. Now, the Texas Code of Criminal Procedure is very clear. When a defendant has once given bail for his appearance, he shall not be required to give another bond. That's 17.09 paren 2. This defendant, all he has done is posted the bond that the state requested, and without any volition on his own, gets taken into ICE custody. I think you would agree with me, Judge. The state has the burden to prove a bond violation. There is a bond violation report. I think we should all agree there's been no bond violation because he had no ability to get an ignition interlock. He had no ability to report to pretrial. So the only exception to this one bond are the following. If the bond's defective, there's no defective in the bond. If the bond is excessive, nobody's arguing the $1,000 bond was excessive. If the bond is insufficient in amount, which is very broad, but I want to make clear that there is no amount of bond, as Ms. Saba just said, that can guarantee that my client can attend court. There's no amount. So I don't think insufficient in amount is correct. The only other catch-all is good and sufficient cause. Now, I did some case law research on good and sufficient cause, and these are new or changed circumstances from which the court can conclude that some cause exists for revoking a bond and setting a different